Your phone wasn't ringing.
Okay, we are live. Good afternoon. This is the Kansas Court of Appeals sitting for oral argument. We have three cases on our docket this afternoon. Our first case is Guadalupe Garcia versus Tyson Fresh Meats. Let me introduce the members of our panel. I'm here today with Judge David Bruns, who's been on our court about 10 years after an extended service on the Shawnee County District Court. And one of our newer judges, Leslie Isherwood, Wichita, a distinguished career appellate practice with the Sedgwick County DA's office. So she is no stranger to this court. She's just sitting in a different place these days. And I'm Gordon Atchison. I just passed my 11th anniversary on the Court of Appeals. I had an extended litigation practice before then. Counsel, this case has been set for argument for 15 minutes aside. I will let you know that we obviously have read the briefs and are familiar with the circumstances of the case. Mr. Osmus is the counsel for the appellant. You have a right to reserve a portion of your 15 minutes for rebuttal. Would you like to do that? And if so, how much time would you like?
Oh, perhaps 5 minutes. But to be honest, I think this will be the shortest argument you've ever heard.
Well, we can always hope. And then Mr. Worth, you get to follow up. You get your full time if you want it, no matter how long Mr. Osmus argued.
Thank you.
Go ahead, Mr. Osmus.
Are you ready?
YouTube is yours. Yes, go ahead.
Thank you. May it please the court and counsel. As I indicated, I think this is going to be the shortest argument this court has ever had. This is a particular case in which the claimant was injured. She was rated by a court-ordered doctor. And at that time, we objected to proceeding since the Johnson case had been decided and they had found that it was unconstitutional, but it was appealed to the Supreme Court. That was pending. However, the judges and even, I guess, the Board of Review refused to do that. So we have ended up in the Court of Appeals. We had raised certain issues going in. Some of those issues have become totally moot in light of the Johnson decision, such as the unconstitutionality. That's a moot issue. We had objected that the finding by the court should not be made until the Johnson decision was rendered as to whether it would be under the 6th or 4th editions. Those objections, those issues probably are gone. We further had objected that we didn't get a work loss. That was an issue. However, in light of the most recent finding, then it would be appropriate that we not have one. However, I think we have to look at the Johnson decision because they're considered by this court. In the original finding, it was found that she had 8%, an 8% body as a whole injury under the 4th edition and 2% under the 6th edition. She got an award, which was 3% by the administrative law judge. However, that finding by the court-ordered doctor was done before the decision came down in Johnson. When the decision came down in Johnson, while it found the statute to be constitutional, it did, in fact, amend the statute in its interpretation. That amendment is significant insofar as my client is concerned here. The amendment that came down in the Johnson decision stated that you start with the 6th edition in finding a functional impairment. And then you go from there and by competent medical evidence, you may alter or change that depending on what the doctor finds. Prior to that, findings were made strictly pursuant to the 6th edition. In the particular case before this court, the rating was done under the old finding by doctors. The doctor was not aware of the protocol change that states basically that more work is to be done after you review the claimant and apply the 6th edition. Then you determine the functional rating, provided that is in fact backed by competent medical evidence. The ratings that we're seeing at this time talk about being rated under the 6th edition, but it also makes the statement that that was the starting point. Because that is the situation, and because there is such a difference in the ratings and the fact that the claimant could have a work loss if it turned out her rating was over 7.5%, we believe the appropriate resolution of this matter would be to order that the claimant be returned to Dr. Pratt and that he make an evaluation of the proper functional rating pursuant to the protocol set forth in the Johnson decision. And gentlemen, that is my argument. And I think that's the only argument and the only real issue that has come out of this case.
So,
Arthur.
Mr. Osmus, I have a question for you.
Yes, ma'am.
If we're looking at the Johnson opinion and the language used by Justice Stegall, that it refers to the 6th edition as a starting point or a jumping off point, and then competent medical evidence is also to be considered, how is that put into practice from a practical perspective, that impairment rating plus competent medical evidence? What would that protocol look like?
Well, what I have seen, the doctors testified that they examined them under the 6th edition, and then they make a determination whether or not the rating that grew out of that examination is appropriate when they consider all other factors. I had one recently that testified that he felt the rating that was set forth under the 4th edition more properly gave a rating for a particular body part than that under the 6th edition. I think, I'm not a doctor, but I know that just because it's a round hole doesn't mean that everything goes into a round hole, particularly if it's square. And so each and every case, I think, has its uniqueness and for the doctor to consider. I really do not expect that there will be a great deal of change, but I do see that the doctors are trying to take into account other aspects as it affects the functional impairment that people have. If you look at the 6th edition, it's really very complicated to come up with any kind of a rating. It's strictly a mathematical, although a lot of subjectivity is demonstrated in it. I think it's a very difficult question to ask, although I think it's a very appropriate question that you have asked.
So could that competent medical evidence, can that increase the rating, or how is that then factored in? What form does it?
Certainly.
What is its ultimate form?
Certainly it could increase the rating. Frankly, from a claimant standpoint, we would honestly hope that it would increase the rating since under the 4th edition, she had 8%, and now that we're saying under the 6th edition, she only had 2%. The difference in the percentage is substantial. And as a practical matter, in this case, had she had 8%, she could have had an award of as much as $130,000. I'm not going to say that's exactly what it would be, but she could claim a work loss. Now she's prohibited from doing that and has basically $4,000. It's a case that shows how really what a problem it is under the 6th edition. In my opinion, I think the Court of Appeals was correct. Supreme Court didn't believe that. And it's possible it could be a lower rating, to be honest. They're not. The point is they are not stuck with what the 6th edition says the rating should be.
Thank
Other
you.
questions?
No.
No. Mr. Worth, we'll go ahead and hear from you then.
Thank you. May it please the court. My name is Greg Worth. I appear today on behalf of the appellee Tyson Fresh Meats Incorporated. As counsel indicates, entry of the Johnson decision by the Supreme Court has alleviated some of the issues we have here today. But just to be clear, that decision has rendered moot the challenge to the constitutionality of the statute, which provides that ratings of impairment in workers' compensation are to be in accordance with the 6th edition, or as we've discussed here today, use of the 6th edition as a starting point. Any and all evidence in the record today referencing 4th edition impairment is irrelevant at this point in time. Clearly, the statute, which preceded the one we have now, and which directed that ratings of impairment be pursuant to the 4th edition, is no longer in effect, and 4th edition ratings have no probative value at this point in time.
Can I stop you there? There's no question at this point that Ms. Garcia gets the benefit of the Supreme Court's decision in Johnson, whatever it means. You would agree with that?
I do agree with that.
Okay. And so for the three of us on this panel who were not work comp practitioners in our former lives as lawyers, what does that mean going forward? I mean, what does Johnson require now?
The statute, which Johnson found to be viable, provides that doctors are to refer to the most recent edition of the AMA guides, that being the 6th edition, when determining impairment. The statute has always provided, even before the 6th edition was introduced, and back when that same statute referenced the 4th edition only, it provided that ratings of impairment were to be in accordance with competent medical evidence and by reference to the 4th edition. Now it says it has to be, ratings of impairment are to be made by reference to competent medical evidence using the 6th edition of the AMA guides as a starting point. I would suggest to this court that that is not a great change from what we had before. We focus more now on the competent medical evidence portion of that statute because it was referenced by the Kansas Supreme Court in Johnson, but it has always been there. And we have always utilized ratings of impairment by reference to competent medical evidence. The question was posed earlier, how is that done practically? Again, doctors are the ones to probably tell us this, but I would suggest to this court that this record before you today makes clear that these ratings from Dr. Pratt, the court-ordered independent medical examining physician, and Dr. Estivo, who was the authorized treating physician and the only physician to see the injured worker on multiple occasions, both their ratings of impairment by reference to the 6th edition are also based upon competent medical evidence. That is made clear by the treatment records of Dr. Estivo and his deposition testimony. At no point in time did Dr. Estivo suggest that his finding of a 3% whole body impairment of function was contrary to the evidence, but he was stuck with it because it was the 6th edition rating brought forward by his findings on examination. No indication that he was ill at ease with the finding of a 3% impairment. His findings on examination, his assessment of the patient, all led him to arrive at that rating, and I would argue that he did so by competent medical evidence. The same is true of Dr.
Well, isn't that an assumption we have to make that all of the docs in this case went beyond a road application or a mechanical application of either the 4th or the 6th edition, and they all applied, each of them, to come up with ratings. So can we really say from this record that they did what Johnson now seems to say?
None of them testified that they did so. We were unaware that that would become the focus when rating of impairment. Again, I think you can say it's an assumption. I would suggest that the evidence bears it out. again, the doctor's findings on examination. For instance, Dr. Pratt noted that he had inconsistent findings on examination, suggesting she was not being forthright at the time of examination. There's nothing in the record which would suggest that the rating of impairment should be greater than Dr. Estivo's finding of a 3% impairment. Indeed, Dr. Pratt put it at 2%. The only rating of impairment out far greater than that is that of the physician retained by the injured worker, Dr. Fluter, who put it at 18 or 19%. But he did so by including other body parts which were not deemed to be credible or relevant to the injury sustained on the job. He included impairment for the opposite extremity and shoulder. Never really a claim for that, no treatment for it.
Well, I understand all of that. And I've seen enough of these cases. I understand there's often a range of ratings depending on who the doc is. But why are we comfortable with concluding that the docs in this case used either the 4th edition or the 6th edition as simply the starting point and not the ending point? I mean, that's the problem I've got is this seems to be a new standard. You're suggesting we can surmise that that's what was done, but how do we know that at this point?
I can't point you to a part of the record which would tell us with absolute certainty that it was so. I can tell you that both the physicians we're talking about, Estivo and Pratt, have been doing this for a long time. They have issued ratings of impairment by reference to both the 4th and the 6th over the years. I think their standing, their experience, and again, their findings on examination all point to the conclusion that these ratings are in accordance with the competent medical evidence in the case, but I cannot point you to any aspect of the record which tells us that definitively.
Mr. Worth, do you agree with the premise that Johnson adopts a new standard?
I do not agree with that because, again, the language that the court focused upon, competent medical evidence, has been in that statute for as long as I've been doing this. It was in that statute before the 6th edition was introduced to it. It's always been there. We have new emphasis upon it, perhaps, but I would argue that this is really not a new standard at all. It's simply affirmed that we are to use competent medical evidence, but now by reference to the 6th rather than the 4th edition.
When I read Johnson, it appeared to me that all Justice Stegall was doing was taking the 4th edition, replacing it with the 6th edition, and then interpreting the statute based on, meaning whether it was the 4th edition or the 6th edition, that based on meant a starting point. Is that the way you interpret it? I'm struggling with whether Johnson simply found that it was constitutional or if it adopted some new standard.
I believe that it did not adopt a new standard, but simply found that the interpretation of the statute is one which leaves in place the competent medical evidence portion, which precedes the discussion of AMA guides additions in the statute. And his decision made clear that he was simply going to substitute 6th for 4th, but interpret the statute the same way. We did not lose the competent medical evidence portion of that statute by the amendment. We are simply substituting treatises, additions of the AMA guides when he interpreted that statute.
Mr. Worth, let me ask you this, and again, this may show my ignorance of the area of the law, but again, in this particular case, you had each of the docs, for whatever reason, using both the 4th and the 6th to come up with ratings, as I recall. It seems to me if what they were applying and striving for was competent medical evidence, each of them should have come up with just a single rating.
I'll tell you why it's done and why you'll see it over and over again in these cases coming up around this time. After the Court of Appeals entered the decision in Johnson, finding that statute unconstitutional, practitioners and our judges, and after it was appealed, so we didn't know what was going to become, we started asking doctors for ratings pursuant to both the 4th and the 6th edition. So when we get these opinions of 4th edition impairment and 6th edition impairment, is because the parties or the court has asked the doctors to provide those.
Well, I sort of surmised that was the reason. But if the test is really competent medical evidence, it should come out as a single one, regardless of what the starting place is, because the competent medical evidence will be a single result.
I don't know that we can,
Right.
because if that is truly the standard, there's no reason to have reference to any edition of the AMA guides in the statute. It matters where the starting point is. If it's 2% versus 8%, I don't know that we can say the competent medical evidence leads us to the same point using both as a starting point. I think what the statute tells us is you arrive at your 6% impairment rating. If competent medical evidence tells you that's not a fair rating, you move it. But to suggest that we always arrive at the same place by reference to the competent medical evidence standard, I think is incorrect, because if that were the case, there'd be no reason to reference either fourth or sixth edition of the AMA guides in the statute.
You've gotten to the end of your time. Do you want to take a minute to sum up for us?
Yes, I don't think there's a valid reason to remand this case, as counsel has asked. He's not asking only for remand to the appeals board, but back to the administrative law judge to take additional evidence and render yet another award. Keep in mind, his ultimate goal here is to obtain compensation for work disability in excess of functional impairment. The administrative law judge made a finding that even if her impairment exceeded 7.5% as required by statute, she voluntarily resigned her employment. By statute, that would also preclude her from receiving a work disability. There is also a finding that she did not sustain a greater than 10% wage loss, another reason she would not be entitled to a wage loss. My client urges you, for practical purposes, as well as the belief that we don't need that in this case, that a remand is not judicially economic, and my client urges you to affirm in all respects the decision of the appeals board.
I do have a
Thank
really
you.
quick question, Gordon, if I could ask really
Yes.
quickly. Mr. Worth, you had, and correct me if I misheard you, but I thought you had just stated that if utilizing competent medical evidence, if you arrived at a rating that wasn't fair, you would move it. Did I hear you correctly?
Well, we are all trying to understand what this means, but that is my perception of it, Your Honor, that if a doctor uses the sixth edition as a starting point and decides that the balance of his examination findings, his review or interview of the claimant leads him to believe that's not a fair rating and that competent medical evidence would move it, that's where that comes into play, as I understand the decision and the statute.
And is that practically, have you seen that in practice?
I have not seen that in practice by reference to either physicians appointed by the court or practicing physicians who seem to believe, by my experience since Johnson was handed down, that those ratings per the sixth edition are pretty much on the mark. I have seen physicians retained by injured workers who see fit to move it. And I have, my beliefs as to why that's so, but we do not have a uniformity of opinion, I believe, at this point in time as to exactly how that is done or whether every rating needs to be moved. I would urge you to find that or believe that a rating pursuant to the sixth edition per the edition without any other change is oftentimes, if not more often than not, truly within competent medical evidence and a fair rating of the injury in question.
Thank you.
I'd like to respond.
Yes, you have 5 minutes, Mr. Osmus. Please go ahead.
We totally disagree with that finding or that suggestion by Mr. Worth, and I'm sure that comes as a surprise to Mr. Worth, but we do. And in that respect, it did in fact create a protocol. And let me read to you basically from that decision. All opinions by doctors must be based upon competent medical evidence. However, it goes on to say, and the court in Johnson spent a lot of time when it says based on, and it says the use of the phrase based on indicates the legislature intended the sixth edition to serve as a standard starting point for the more important and decisive competent medical evidence. That is the application of a standard while setting the legal parameters of any possible resolution leaves work to be done. And the leaves work to be done is exactly what we're talking about, because just because the sixth edition, when you do all the manipulation, you come up with something, says it's 7, doesn't mean that the doctor says, now, wait a minute, I believe these other factors must be taken into account. The case also refers to an in-depth analysis, and it talks about a case that was in Kansas with factors, guidelines, and standards falling in between. So there is, in fact, a new way in which there is to be ratings. They didn't find Johnson to be unconstitutional, but they found that there was if you read it, the legislature meant that the 6th edition was only a starting point. If it's a starting point, it means you have a right to go outside that and make additional findings based upon your opinions and what you as a practicing physician has learned. So he is totally wrong. However, it is true that all opinions must be based upon competent medical evidence. They even asked me what comparable evidence was before the board, and I assume competent medical evidence is what any doctor that examines someone puts down for his rating, or he wouldn't have believed it was competent medical evidence. And it's pretty evident that there is a difference of opinion as to ratings. But that's it. It is not that it's the same old thing. That case means something, and what it means is that you only start with the 6th edition. You consider everything. What he can do, what he can't do, what has been done to him, where he is at that point in time. And based upon all of that, you can then give an opinion. And you're not stuck with what it may be if you ground it through the 6th edition. Prior to Johnson, there were no doctors that believed, or even people that did the ratings, that you could go outside what there was in what was said to be done in the 6th edition. You were kind of stuck there. It was also same with the 4th, but in the 4th, there was a statement that said a doctor could also refer to his own prior knowledge. That's all I have, unless there's something else.
Any questions? Thank you, gentlemen. We will take the case under advisement, and we will let you know what we think Johnson means.
Thank you.
Thank you very much.